Good afternoon, everyone. My name is Lucy Sandell, and I work with the Career Development Team here at the University of Chicago in Hyde Park. I'm delighted to welcome you to our webinar entitled Legal Issues for Startups. The recording will be shared with all registrants in the next few days, as well as the slide presentation. Today's speaker is college alumnus Justin Agans. Justin is a firmly mediocre guitar player who has a new baby, so congratulations to Justin and his wife. Before I hand over the controls to Justin, let's do a quick poll. Let me bring it up. Okay, I asked people to start answering. We're going to run this poll for about 20 seconds, and then you'll be able to see all the answers. Great, so it looks like about 3/4 of you have started a business at some time or another. Justin, I'm going to hand over the controls to you.
All right, thank you, Lucy, and thank you to everybody who is joining us via the internet today. So as Lucy mentioned, my name is Justin Agans. I graduated from the college in 2006. After graduating from University of Chicago, I spent some time traveling and then went on to graduate school where I got a joint degree in both law and business. And so the marriage of those two areas is where I now play and where I now live as a lawyer who works with startups and small to medium-sized businesses at a small firm in Charlotte, North Carolina. So this presentation will cover sort of typical legal issues for startups. And that's what I do on a day-to-day basis, and we'll kind of go over those high points. The presentation will take about 25 or 30 minutes, and then at any time you can ask questions, and Lucy will help guide us through the Q&A section after the initial presentation is finished. So before we jump off into the presentation, I'm not going to read this, but as a lawyer, I have to do classic lawyer things like give disclaimers that this does not create an attorney-client relationship, blah, blah, blah. You can read that as your leisure, and let's jump into it. So we're going to cover kind of what I think of as the 5 main areas that startups need to think about as they're thinking about launching, and then as their company grows in the first 12 to 24 months. So formation, key contracts, hiring, IP, and raising capital. And we'll go into more depth on each of those subjects and ask questions along the way, and then we'll answer those towards the end. So first up, with formation, we've got entity choice. This is almost always the first question that I get when a new client comes in the door, and that's the decision about whether to form as a Delaware corporation, like a Facebook or an Uber, or whether to form as an LLC. Now, where I'm located in North Carolina, we typically, most people, a North Carolina LLC will do the trick. And as you'll see in that chart there's a few main reasons why an LLC is usually the right answer. So first is that it's cheaper, and it's cheaper in 2 ways. It tends to be cheaper to have a lawyer draft the documents that are part of the formation piece of forming an LLC. And then the second piece of that is that if you form a Delaware corporation, you have to pay state filing fees in 2 states. So the state of Delaware and then the state where you'll actually have your headquarters and be operating. So just to give you a practical example, for North Carolina companies who form a Delaware corporation, they have to both pay the state of Delaware filing fees as well as the $250 fee every year, which is the filing of the certificate of authority that gives you the right to operate in that state. and so this is just a little bit more expensive from a state fees perspective. The second advantage for an LLC is that it's less formal in terms of the ongoing administrative aspects, as well as the corporate structure piece of it. So for an LLC, you can be a solo person who is both a member, meaning an owner, and a manager, meaning like a CEO. Whereas with the Delaware Corporation, you have to not only have officers like a CEO and president, you also have to have a board of directors, which makes high-level strategic decisions. And when you have a Delaware Corporation, you're essentially tied to a more complex structure that is certainly appropriate for companies that are, like a General Motors or Facebook, but makes less sense when you're a startup who is bootstrapping things and trying to keep things simple. So the final benefit that we'll cover today for an LLC is the single layer taxation. So that's in contrast to a corporate taxation, which is at 2 levels. So in an LLC, the taxation flows through to you as an individual, meaning that you just pay tax on the profit that the company makes, and that flows through to you. Whereas for a Delaware corporation, you've got double taxation, meaning you pay taxes on the corporate profits, as well as on the dividends that you receive as an individual shareholder. We'll flip over to the Delaware Corporation advantages, and there's 3 listed there, but really I like to think about it in two main ways. A Delaware Corporation is advantageous in the event that you know that you're going to go raise traditional startup capital from venture capital firms or sophisticated angel investors. A lot of times those angel investors or venture capital firms will actually require that you're a Delaware corporation because they are familiar with the Delaware corporate law that's associated with forming companies. The second reason is that equity compensation, including vesting, is easier to do in a corporate format due to the fact that corporations have been around for a lot longer, and the IRS has given us clear rules as to the tax implications for employee compensation in an equity format. So from that perspective, if you're going to be the typical startup that needs to attract employees with a combination of typically a lower salary but some equity and ownership in the company, the Delaware Corporation can be a better fit from that perspective. One thing to keep in mind, though, about this choice is that it's not final. So you can convert from an LLC to a Delaware Corporation down the road if you want to save some money and operate a little bit leaner up front when you're first launching, and wait to do the conversion to a Delaware Corporation until your startup's got some customers and it's made some money, and you know it's going to be a going concern, and you're getting ready to go raise that first round. I've had plenty of clients do that, and there's nothing wrong with that. The one thing I will say is that if you go that route, you oftentimes want to go ahead and do the conversion before your ownership structure gets too complicated, meaning you've added investors and such. So the next slide kind of talks about some of the other formation issues that go beyond entity choice, and there's kind of a few main key issues that founders have to think about. And the number one most difficult piece is deciding on the equity split in a situation where you've got multiple co-founders. So if you've got 3 co-founders, say, and one of them is going to be the CEO, who's going to go help you raise money and just be the head of the organization. The second person is going to be the CTO or the chief technical person who's going to build the platform that your company will run on. And then the third person is sort of just your kind of operational person who makes sure that things run smoothly and just does whatever needs to be done, but doesn't have experience running a startup or building technology. When you think about the equity split there, the person who is just an operational head is probably going to get a smaller slice of the pie up front, given the relative value of those three roles. If you want to kind of learn more about how that works, there's a startup podcast that was launched by Gimlet Media, which is run by Alex Blumberg, who has a history of being a producer on This American Life, and he co-founded Planet Money, and he actually documented his startup journey, and it's a really neat window into some of those issues. In episode 3 is where they actually talk about the equity split issue. Next up for important issues is the decision-making authority. So who gets to decide what sorts of decisions for the company, and how formal do you make that? If you've got somebody who's the technical background who does coding, they should probably be the person who's making decisions about technical aspects of the product that's being launched. And if it's a CEO, they should probably be making the decisions on what the pitch deck looks like. If it's a CMO, a marketing person, they should have the final say over your marketing messaging and the amount of money that you're putting into Facebook ad campaigns and Google AdWords and such. So it's important to lay out in advance who has the power to make what types of decisions, so that when you're in the middle of the launch piece of it, you're not trying to fight over who has what authority, which often happens. Next is the vesting schedule. So in startups operate a little bit differently in terms of the way that equity happens, as compared to a typical, say, LLC, where it's static equity, meaning, let's say you just split it 50-50 with a co-founder, and everything is vested up front. In a startup, it's typically a 4-year vesting schedule, which means that every month for 4 years, a portion of the equity that was agreed upon as part of the equity split will vest. And what that does is it makes sure that the co-founders' incentives remain aligned with making the company successful. So if a person leaves after only 1 year, they only get 25% of the equity that they were awarded as part of being a co-founder in the beginning, which makes people stick through the hard times and also rewards the people who do. IP assignment is another key piece of the formation. And why this is important is because oftentimes people will have been working on ideas far in advance of when they actually form the company officially from a legal perspective. And so part of the legal documentation, and this applies whether it's an LLC or a Delaware corporation, is to make sure that whatever intellectual property has been created, whether it's the minimum viable product for an application, or a business plan, or the name of the company, all of that sort of intellectual property should be assigned up front as part of the formation, to make sure that the best interests of the company are being respected. So after you get the formation out of the way, there's kind of a number of key contracts that most startups will face. So I'll just kind of quickly run through them and talk about a few of the points of what they look like. So first is terms and privacy policy, and most of you who have signed up for anything online will have checked the box agreeing to terms of service without having read it, but that terms of service is sort of the key contract for software applications, and it will determine what usage is allowed, payment terminology, and other associated dispute resolution type of language. And it's the key contract for instance, software providers who are on the cloud. The privacy policy is another really important contract that's it should be on every website. And that basically is what tells customers what sort of information is going to be collected through using the website, as well as what the company is going to do with that. And it's really about giving notice to customers more so than anything else. So the next key contract that might come up would be a supplier or distributor contract. And so this more applies to sort of product type of companies who have a physical product and they might need to source things like as simple as nuts and bolts or other components. But when your company relies on a supplier to provide you with the raw materials you need to produce a product, or a distributor who's the primary entity responsible for getting your product to consumers, you want to make sure that those contracts are looked at and drafted and negotiated by someone who does that for a living. Otherwise, you put your company at risk. So the third one applies to companies who start without having a technical person as part of the co-founding team, which is fairly common. So basically, you're hiring somebody to develop your website or your application and provide that to you, which then you would push out to the public. Now, the most important thing for that contract will be making sure that you have full intellectual property rights as part of that contract, which unfortunately is less common than you might think. And it is again an area to be careful of if you're one of the companies that does not have a technical person who's on staff. Last, but certainly not least, is office space. So I've got there listed a few of the co-working spaces that are in Charlotte. And the reason why I have that kind of called out specifically is because it's an area where startups can really avoid any long-term risk and be in an affordable space that's around other creative individuals or companies that can be really conducive to helping your company move forward. But the most important piece of that is that co-working spaces are month to month as opposed to a traditional office space lease, which could be anywhere from 3 to 10 years. So for instance, as a lawyer, I sort of need a space where I can meet with clients and I have a traditional lease that was necessary for us because we're client facing. The same for like a doctor's office, for instance. But for a typical startup where there's really no need to meet with clients as a regular part of business, typically it can be both cost effective and a great risk mitigation strategy to work at a co-working space. So next up is hiring, and this is one of the hardest things to get right as a startup when you are making your first hires that are beyond that co-founding team. The best advice I've heard can be encapsulated in point 1 there, which is hire slow and fire fast. The cost of a wrong hire is really, really high. The amount of time and energy that you're going to spend training people is extraordinary, and it really makes sense to invest the time into the hiring process rather than hiring fast and then realizing after a few weeks of training that the person is not a right fit. Second point under hiring is the distinction between employees versus independent contractors. We've got the Uber logos there because they have been in legal battles across the country about this particular distinction. Now, it can be advantageous for a company to try to categorize people as independent contractors, but it's not, the contract that you have somebody sign doesn't determine whether they're an employee versus an independent contractor. It's the actual reality of the relationship. Now, there's like a 20-factor test that the IRS uses to make that determination, but you can kind of think of it in two pretty simple ways. The first is the degree of control that you exercise over an individual. So you can think of things like, do you require a person to be at work at a specific time or work at a specific location? Did you give them training, or can they complete a task however they see fit? Those sorts of considerations go into the degree of control. And then the other piece of it is whether a company is that person's sole source of income. And if you are that person's sole source of income, or the vast majority of it, it's much more likely that they're an employee than an independent contractor. The third point here, which is a distinction in terms of the term for which you hire someone. And so it's at-will employment versus a specified term. So at-will means that either party can terminate an employment contract at any time for any reason that's non-discriminatory. And then a specified term is, let's say a one-year contract that's common for teachers, for instance. Now there's a difference here between whether you are a company or whether you are someone who's thinking about working at a startup. If you're a company, it's in your best interest to have at-will employment, right? Which means that you can fire somebody at any time for any non-discriminatory reason. Whereas as an employee, you might like to have the certainty that comes with a specified minimum term of, say, a year or 2 years. In particular, if you're leaving a job to work, an established job to work for a startup, that can be in your best interest. The fourth point here is that if you're a company and you're hiring people, you want to make sure that your contract, whether it's for an employer or an independent contractor, clearly establishes that any work created within the scope of the job belongs to the company. There's a presumption in U.S. law that the creator of intellectual property is the owner of that intellectual property, unless contractually stated otherwise. So it's really important to have that in any contracts where you're hiring someone to create IP on your behalf. And the last piece to talk about here, which we touched on earlier, is equity incentives. So as a startup, you're often cash poor, which means that you're often, to start with, paying below market rate for talent. And so the way that startups often attract top talent, even when they're not paying market rates to start with, is by also offering equity compensation, which is usually in the form of either a stock grant or stock options. And it can be a powerful tool to lure away talented individuals who otherwise wouldn't be able to justify working for a startup, given the disparity between what they'd get paid at the startup versus at a more established company. Lucy, this might be a good time to do that second poll and get a sense of the reason why people were interested in joining the webcast today.
Great, I'll pull it up. Okay. Sorry, it's being tricky for me today. Here we go. If you want to go ahead and start putting in your answers, that would be great. Give you all a few more seconds, and then I'll close and share. Okay, so almost 40% of you want to launch a startup, and 35% of you have already launched a startup. So that's great. It's a nice variety of people. I'm going to hide the poll results now and pass it back over to Justin.
Thank you, Lucy. All right, so we'll move along from hiring to intellectual property. So there's a few different types of IP, and I'll briefly touch on each of them. So the first is the trademark. And so as that description talks about, word, phrase, symbol, design, and the idea is to be able to allow consumers to identify the good or service and distinguish that from other potentially like goods or services. So when you choose a name, and you put that name then out in commerce by promoting or marketing your good or service, then you're putting yourself in a position to where you can secure a trademark, which then allows you to defend that. So I'll kind of start with the second point there. Google is your best friend in terms of figuring out whether somebody else or another company already has that good or service. So go to town on Google and see if you can find out whether anybody is already using that name or a similar name. And then the second thing you can do is actually pretty easily navigate the USPTO website, which is the U.S. Patent and Trademark Office. And you can actually search to see if somebody already has the name that you're thinking about, or a variety of names that you're considering, to determine whether or not it makes sense to go forward with a particular choice. So that first bullet point there is sort of meant to illustrate what can happen when one company who has a trademark feels threatened by another person who's in a similar space. So you probably have all seen the Monster energy drinks, and that company is well known for defending what it considers to be potential infringement. So for example, there was a brewery in Vermont who created a beer called the Vermonster, and they received a cease and desist from Monster energy drinks. And part of why Monster was able to pursue that is because they had filed a federal trademark for their energy drinks. Another example of someone who has trademark protection and is looking to protect that is the Jack Daniels versus Broken Piano for President design trademark issue that occurred. As you can see, those are fairly similar designs, and I suspect that the Broken Piano for President novel, that's a novel book cover, took some inspiration from that Jack Daniels design. And what happened there was that Jack Daniels reached out, said, "We have a trademark for the design. It looks like you have been inspired by that. We have to protect our trademark. If you would be willing to change the cover for the second release, we would even help you pay for that." And so they were able to come to an agreement to make sure that there wasn't future infringement there. And typical trademark disputes are not quite so friendly, but Jack Daniels handled things in a way that certainly made the author of Broken Piano for President willing to kind of settle that. But it goes to show you that it's important to whether it's design or just the words in your company's name, to really do your research and make sure that you're not stepping on somebody's toes, because the litigation involved, if you're not able to come to a settlement, can be extraordinarily expensive, tens to hundreds of thousands of dollars, and nobody wins if that happens except for the lawyers. So the next piece of IP is copyright, and so copyright applies to everything from books to movies, songs, computer software, etc. So two recent examples of infringement there was when Blurred Lines came out. It sounded similar to an old Marvin Gaye song, and so Marvin Gaye's estate actually sued Robin Thicke and Pharrell, and they actually won a multi-million-dollar judgment against the owners of the Blurred Lines song. The second second example is software code. If you copy software code or integrate that into what you're doing without the approval of the owner of that, then you can get into difficulty with the owner of that if they decide to sue you, which happened with the famous Google versus Oracle lawsuit. And the big tech giants are often engaged in this sort of litigation. But the most important piece here is just to make sure that there's not any copying of software code, in particular when it comes to startups. It can be tempting to do that as a shortcut, but the result, especially when a startup is going up against an established tech giant, is often just bankruptcy for the startup. One thing to keep in mind is that you can't sue for copyright infringement unless you register your copyright. Luckily, it's not very expensive. As you can see, it's only $55, but it's an easy step you can take to protect the IP that you create. The last IP that people deal with is patents, and these tend to be much more technical in nature as opposed to trademarks and copyrights. They're expensive to procure, but they can also be important in terms of protecting the technology that you develop. Just as an example, in the iPhone or Android that most of you have, there's hundreds of patents that are associated with that device. And in 2015 alone, Apple had almost 2,000 patents. The thing with patents is that because they're expensive to get, it often makes sense to go ahead and build technology and get a little bit of market traction before engaging an attorney to provide the help to get that patent secured. But that's sort of a judgment call that you have to make, and something that your typical patent attorney can walk you through in terms of when the right time is for you or your company to file for that patent. So last but certainly not least is raising capital. So when you raise capital, there's two main ways that you can do it, debt or equity. With debt, the benefits are as follows. There's no dilution, and what all of that means is that you get to keep all of your company. You get to maintain control because you aren't giving up equity in your company or the voting rights that accompany that. And then the last two kind of go together. You get to avoid securities laws, which means you basically don't have to deal with oversight from the Securities and Exchange Commission. When you raise capital in a traditional sort of startup equity way, you have to file securities filings at both the federal and the state level to apply for those exemptions, and that tends to be costly. And so debt, whether you're going through a small business administration loan or just a typical local bank, tends to have cheaper transaction costs. Now, the benefits of raising in a typical equity fashion for startups, first and foremost, you don't have to pay it back, and that's nice because you don't have a liability on your books. The second is that your investors become advocates for the business, meaning that they will do everything in their power in terms of opening up their network to you and providing strategic advice to help your company succeed, because success for the company means success for them. The third point is that you get to grow faster, and that's related to the first point. Basically, when you don't have to pay back the money, you get to fuel growth, whether it's through marketing or bringing on additional personnel, and that certainly does allow you to grow faster. And then kind of the last point there is a smaller one, but whenever you raise money as a startup, it's an opportunity to get your name out there into the public, and put out press releases and have local and national news do a story, and that can be beneficial in terms of the growth trajectory for your company. And the last point I'll make there is that you don't have to choose between the two. In fact, I'm working with a client right now who secured an SBA loan for $150,000 last month, and then we're also just starting the process of helping her and her company raise up to $500,000 for growth capital purposes to help expand the company. And so there's nothing wrong with using a combination of both. And again, it's a decision that's personal to the facts and circumstances of your company. So with that, I will just say thank you for your attention, and I am happy to take any questions and talk further at this point. Lucy?
Great. Yeah, we definitely have questions. The first question is, what documents are used to issue shares to founders, employees, advisors, and early investors? Is it share certificates, share purchase agreements? Well, you'll answer that. Go ahead. Sorry.
Sure. So the documents are different for advisors versus co-founders versus investors. So co-founders, I'll use just the Delaware corporate structure as the way to explain this. So with a Delaware corporate structure, for co-founders, there's typically restricted stock purchase agreements where you set the value of the shares to be really low It's called the par value, typically 1/100th of 1 cent. And so, for, let's say, 6 million shares, you might pay $600, and then those shares would vest over time. And so it would be restricted stock purchase agreement, and then that would be tied as well to the confidentiality and intellectual property assignment that you make as a founder as part of the formation piece. For advisors, you'd have a combination of an advisor agreement, which would lay out what the advisor is going to do in exchange for the equity. So typically that'll be, meeting once a month for an hour to discuss a topic that the advisor has specific expertise in. So for instance, if you have an advisor who's an expert in sort of digital marketing and strategy, you would have that in that short advisor agreement that would lay out what advisory services they're providing and how often. And then that would be combined with a restricted stock purchase agreement or a restricted stock grant agreement, which is the services for equity part of that arrangement. For investors, it depends on the type of equity you're giving them, but the short answer is that typically when an investor comes in, they're just purchasing the equity. So instead of it being a restricted stock purchase agreement, it just would be a stock purchase agreement. And then that would also contain sort of additional protections for the investor in many cases where they have to approve certain things, for instance, like a sale of the company, or they might have the right to participate in future rounds of fundraising, which is often categorized as sort of anti-dilution language, meaning that they have the right to participate pro rata so that they get to maintain their equity percentage in the company, for instance. And then all of them would actually be issued shares in the company, and those could be paper, stock certificates, or they are oftentimes nowadays just electronic. I think I probably answered that in more detail than was necessary, but I think we're ready for the next question, Lucy.
Great. I think more detail is good, actually. Okay.
Okay.
What's the single best tactic to avoid legal conflict among founders down the line? Hyper-specific deal point contracts that are predictive?
Sure. So what I would say is that I'll give you two, and they kind of work together rather than just one. Essentially, it's clear and regular communication, and so that does encompass getting as specific as you possibly can up front in terms of what's expected and how people will work together and who has the final say in what areas. Most companies have multiple co-founders, and so it's important for there to be trust among those co-founders, as well as an understanding of, like I said, who has the final say. A marketing person shouldn't have the final say on technical details, and vice versa. That's definitely true. I think there we go. So what I would say is get as specific as possible in terms of expectations. So I think, whoever asked that question, I think, their initial thought was right, to be as specific as possible, but then regularly communicate on those points and be willing to update those specifics, as the facts and circumstances change. The world that a company that's a startup lives in is changing very fast, almost as a rule, and so some flexibility there is also an asset. Next question.
Thanks. Sure. Could you give more specific comments on legal-oriented areas? For example, when you mention equity incentives, could you describe the steps and documents to set up?
Sure. So if you're going to create an equity incentive program for your company, Well, it's different depending on the structure, but I'll use the typical startup structure as the example here. So for Delaware Corporation, in order to provide stock options to key employees, what you do is you first set up an employee stock option plan. So that's a document that lists out what the components of the plan are, how the decisions are made for that, and kind of lays out those rules and regs for how that you'll internally deal with that. And then there is also a companion document, which is sort of the template that you'll use as an award for each individual employee. So the plan is the general document that kind of governs how employee stock options are handed out, and then the award is what's given to each actual employee. So like Jane Smith, I would give her 1 million shares that would vest over 4 years, and so that would be the details of Jane's specific award would be in the award document. Now, that's the simple version. There's a little bit more to it because you have to get this is going to get kind of detailed, but basically, if you're going to grant employee stock options, there has to be a fair market value that's established at the time that the option plan is created and updated yearly. So typically that happens by getting a 409A valuation, which means that you basically hire a finance expert to value your company, and then that sets the fair market value for the stock options at the time of the stock grant. And then, let's say in 5 years when the person exercises that option, obviously the stock hopefully will be worth more than it was on the grant date. So that's one kind of key piece of the puzzle. And then the other sort of internal document is that the board of directors will have to approve any stock grants as part of the equity compensation plan, which is typically a formality, but certainly something that needs to be part of the documentation process. And then last but not least is the employment agreement that just kind of states why you're, for what role you're hiring the employee, and then the different components of compensation, which is typically kind of a combination of salary and maybe bonuses, plus the equity piece of it. So I guess in summary, you've got the employment agreement, you've got the stock option plan, you've got the actual stock award agreement, you've got the board approvals, and I think that's it. Hopefully that was enough detail. I think we're ready for the next one, Lucy.
Sure. Any recommendations on sourcing cost-effective legal advice assistance with agreements when you're in a startup mode? The most cost-effective way to do it is to find a lawyer in the community who works with startups regularly, rather than finding somebody who's sort of a general business lawyer or just a general sort of practitioner. The hourly rate will probably be a little bit higher, but they'll be able to give you specific startup tailored advice quickly. The other thing about working with somebody who knows the startup world is that they won't, I guess this sort of is predicated on that person having integrity, but they won't have you do legal work before you need to. So let me give you an example. Like if you were to go to a startup lawyer, and say, I want to be cost conscious and I want to, essentially get the additional legal documentation as I need it and not pay for everything up front. Initially all that you need is sort of the typical formation documents that, include the certificate of incorporation and the founder documents, including restricted stock purchase agreement and IP assignment and confidentiality. You don't need to have a stock option plan right off the bat. As an example, you may need that down the road, but
that's sort of a sign of growth for the company when you're having to hire outside individuals beyond the co-founding team. So that's one piece of it. I think the other is by making sure that you're doing a little bit of research yourself in advance. There are resources like TechCrunch which can tell you quite a bit about sort of what typical legal documentation is necessary at what steps. The short answer is that unfortunately lawyers, unfortunately for startups, lawyers aren't cheap, and neither are accountants. But those are two pieces that it tends to be worth the money as long as you're working with somebody who's got experience specifically with startups. So it's important, I think, to interview a few different options for any service provider who you're going to work with, because they'll help you navigate a process in a way that will mitigate risk down the road, such that it saves you money in the long term, certainly. But there's really no cheap way to find somebody to help you navigate the process. If you're just looking for documentation, I mean, you can do Google searches for all the key documents and find basics. I think the value for what lawyers bring to the table is not, that they have the best form documents. It's that they have the experience to help you navigate decisions in an intelligent way. And they've seen what sorts of strategies and tactics will help you avoid, co-founder problems down the road, versus, having a situation blow up. And so I think what I'd say is, making sure that you find somebody with great experience is probably the single best way to keep costs low. But there's really no way to do it on the super cheap, unless you're willing to take the risk that that your form documents contemplated everything that could go wrong in the first place.
Okay. This person wrote, if I wanted to invest in a startup, example, on Angel List, but was not an accredited investor, how would I go about doing that legally?
So that's a somewhat complicated question. The legal concerns are less on the investor side than they are on the company or what's called an issuer side. So it's the company or the issuer that really has to deal with all the compliance. And so whether you're an accredited investor or not doesn't necessarily make your liability increase. And there's two main ways where somebody can be an accredited investor. That's an individual. So the first is that you've made $200,000 a year for the last couple of years, and it's foreseeable that you'll continue to do so. And the second is that you've got a net worth of $1 million, exclusive of your primary family residence. So, and those two things are supposed to be a proxy, right? They're a proxy that you have the sophistication necessary to make smart investment decisions, combined with the fact that you can afford to lose the money if things don't go well. And why that's important is because startups are incredibly risky investments. And so I think, it's difficult for me to say sort of you should or shouldn't invest if you're not an accredited investor. I will tell you this. I tell my startups that under no circumstances should they raise money from unaccredited investors because of the liability risks that it increases for the startups themselves. There are some crowdfunding sites that are starting to pop up as a result of the Jobs Act and the equity crowdfunding platforms that are trying to meet that demand. And those have some rules regarding sort of a percentage of your income as an unaccredited investor that you can invest each year. And so, that's a good place to start in terms of looking at how you can invest as an unaccredited investor. I'm not sure that AngelList has gotten into that game just yet, but they probably will if they haven't yet. The short version is just to be careful and do your due diligence, and that you, as the investor, you're at less risk than the startup.
Great.
Go ahead, Lucy.
Thanks. Is there a difference between awarding employees shares with vesting versus awarding, stock options?
So the stock options usually vest. So although they don't have to. So what all that vesting means is that you don't have the right, like you don't own those shares or have the right to purchase them, which is what an option is, at the moment of the grant. So essentially, so let's say you take a job and a company says, all right, we're going to give you, 500 stock options right now, plus an additional 500 that are going to vest over 2 years. That would be maybe a way to illustrate the difference. So the moment that you take the job, you would have the right to purchase, the option to purchase those 500 shares at a defined price at the moment that you sign the contract. Whereas the additional 500 shares would only vest over that 2-year period, typically on a monthly basis, but it could be on a quarterly or an annual basis. So the stock option, the grant agreement or the award agreement would specify when you get the right to purchase those options. And sometimes it's fully vested, meaning that you have the right to purchase all of them up front, whereas other times your right to purchase those options will vest over time. But from a company perspective, you can do it both ways. And then from an employee perspective, you just have to look at the details of what the option award agreement states.
Great. Well, we're coming up to 12:55. So I'm sorry, I'm sure there are questions out there still that haven't been answered, but I want to be courteous of Justin's time, and there are people peeking in the window who need to use this conference room. So I just want to thank you all for participating. Justin, you did a terrific job. I've learned so much, and I'm sure most people have as well, especially the 39% who want to launch a startup and the 35% who've launched a startup who participated. So thank you so much. And I look forward to having some of you, if not all of you, participate in more of our Mind Your Career webinars. I really enjoyed it. Thank you so much, Justin.
Thank you, Lucy, and thank you to everybody who joined us today. Have a great rest of the day.
Thank you. Bye. Bye, everyone.